and you can begin your remarks when you're ready.
Thank you. Good morning, and thank you for the opportunity to be here again to speak with you this morning. My name is Gretchen Kramer, and this is my 4th time applying for the Court of Appeals. I'm applying again because this position is how I would like to spend my days on this earth. I really value appellate work. I enjoy it. I value public service, and this is the role that I would like to fulfill. Why me and not another one of the very many qualified candidates you'll see before you today? What I can offer is a breadth and variety of experience. I have 22 years being an attorney, primarily as a civil defense attorney. I have a fair amount of experience in appellate work. I've completed about 200 cases, appellate cases in state and federal court. But I also have experience at other levels. I've done administrative hearings. I've done work before the district court. I've appeared in both state and federal court and handled small cases like petition for gun rights restoration and big cases like class actions and all kinds of cases in between. Much of the federal work that I was involved in involved conditions of confinement litigation, which is a tort-like analysis of constitutional rights. It's not very often that lawyers get to interact with cases with constitutional rights, and I really enjoyed that work when I was able to do it. I've litigated issues of first impression. I'm also dually trained in law and psychology, having both a JD and a PhD. I hope that my psychology training has made me more reflective as an attorney and adds value and expertise in decision making. I worked for the Attorney General's office for 15 years, 5 of it as a supervisor, supervising a group of 53 attorneys. Part of the time when I was there, a number of the attorneys who had worked their full careers for Attorney General Miller retired, as people get to do. And I was part of the team that hired the new group that works to support DHS now. And it was very rewarding to find the new talent and to help them on their way in their careers. During the times of transition as division director, I tried to pick up the work that wasn't covered. And so during my time, I did a little bit of everything there, from child abuse registry appeals to Medicaid to employment litigation. After 15 years of working on the same kinds of problems with the state, I decided it was time for a change, and I joined Mid-American Energy in May of this year. Now I do transactional work, which is very different, but also a really refreshing change. Negotiations are less contentious because the same goal is on everyone's mind. We want to come to an agreement that everybody thinks is fair. My other roles before my 2 most recent, I worked as an associate for the Whitfield Law Firm and served as a law clerk for the late Honorable Judge Fagg of the 8th Circuit, and also as staff counsel on the 4th Circuit Office of Staff Counsel. It was in these earlier roles that I had the most experience with criminal law, which I raised because I recognize that most of the work of the Court of Appeals is criminal and juvenile and mental health. And I've done work in all of those areas in the appellate realm. While I was at the 4th Circuit, all criminal appeals came to the Office of Staff Counsel. It was considered sort of a rocket docket there. Apprendi had just been decided by the United States Supreme Court, and that was the case that upended the sentencing guidelines. So I was there while people were trying to figure out, is this a watershed case? Does it apply on collateral review? But the major thing that I learned as an appellate law clerk is the variety of appellate work and how enjoyable that is to see very different cases on any given day. Outside of work, I spend most of my time raising my family. My daughters are 12 and 15 and involved in dance and softball, so I spend a lot of time in the car. My husband of 21 years, John, is currently the fire marshal in Altoona. I resumed teaching at Drake University recently. I had taken an 8-year break. I taught for 10 years, and then when my kids got a little busier, I stopped that, and they're now older, so I thought it was time to resume. And I joined right in time for the pandemic, so we taught over Zoom for a period of time, but now we're back in the classroom, and it's really nice to see the students in person again. I'm not a native Iowan. I moved here knowing nobody but my husband and Judge Fagg, who was my first employer. But my husband and I have built our family here. We've built our careers and our life. We've made our home here, and Iowa is home. I would like to point out that even though I am a Des Moines attorney, I do understand rural life and value that. I came from a very small town in Oregon. The county is the size of Massachusetts with about 7,000 people. So some of the situations I think I can relate to living in rural Iowa, both the challenges and the difficulties finding services, but also the joys of having a smaller community and a tighter connection to the land. Thank you very much for the opportunity to appear for you again today.
Thank you. And we'll start our questions with Commissioner Spies.
Good morning, Ms. Kramer.
Good morning.
Good to see you again. You certainly have a really diverse background, legal and otherwise, and I was particularly drawn to your experience with Judge Fagg, who was a unique personality on the Eighth Circuit. Tell us a little bit about your experience working with him and how that has helped you to develop an understanding of the appellate process.
Sure. I think any of your early experiences are very formative and foundational. Judge Fagg had a very distinctive writing style. He had all of his lawyers, he called us lawyers, not law clerks, read plain English for lawyers and write in a very plain and simple, straightforward style. His goal was if you had to read a paragraph twice to figure out what it meant, then the author missed its mark. And I do try to carry that forward. He would also say if you applied for additional pages, if you wanted to file an overlength brief, he would always grant it, but he would stop reading after page 20. So he valued being concise, he valued being to the point, and he valued having the litigants be able to understand the rationale and not just lawyers who were in the case. I tried to take that with me in my career.
Thank you.
Commissioner Roberts.
Sure. Thank you. Good morning. So we met a couple weeks ago for lunch, and we talked about a number of things. One of the things we talked about that I kind of wanted to follow up and just clarify in this conversation today was just around judicial philosophy and how you would think as a judge and resolve issues of law and make decisions as a judge. I think when we talked, you described that when you were facing an issue that you were resolving, you would look at the text of the law, you'd look at precedent, you'd look at the surrounding law, and ultimately try to focus on coming to a reasonable outcome. Do I have that about right? Do you want to clarify that? Do you want to provide any illustrations of that?
No, I think that is right. I think you start with the text of the law that you're trying to read, and as the old adage goes, if there's a statute of the Constitution, you read it once, you read it twice, and you read it 3 times to see what it means. In our conversation, you brought up the case of State versus Wright, so I did go back and read that a little bit. And it's really an interesting case because the Fourth Amendment jurisprudence has changed quite a bit, and I think we're asking a lot of our judges to figure out what to do with search and seizure law in light of technology that I don't think the founders knew about, or you know. So that would be a great opportunity for our legislative and elected officials to put some guidelines out there on what search and seizure law should be. I think the judges do their best, and starting with the words on the page, but where people start to disagree is when the analysis goes a little further than that.
Thank you.
Commissioner Parrish.
No questions, thank you.
Commissioner Hartkoff.
No questions, thank you.
Commissioner O'Brien.
Thank you. Ms. Kramer, in your 6 or 7 months as a transactional attorney, do you see some principles and advantages and concepts in that area of practice that might be applicable to the Court of Appeals in a way that might improve that process?
Interesting. Well, I do think that the ultimate goal of all of whether it's litigated or transactional is to come up with a resolution that people can agree upon to resolve conflict in the case of litigation. So looking at those practices and keeping an open mind for all of the different ways to do that, I think is helpful. More than transactional law, I think I want to point to collaborative law and how that's a new and evolving area, and the court can support those in its rulings and support the new ways that people are finding to resolve their issues and the new ways that people are finding to do business. I think I would look to that.
Thank you.
Commissioner Graber.
Good morning. Thank you for applying. Explain what you would expect in your transition from what you're doing right now with Mid-American into becoming to a judge on the Court of Appeals. Like, what do you think would be your toughest transition point?
I think you can ramp up to the volume again. The volume is the biggest challenge on the Court of Appeals because of the number of cases that the judges are expected to resolve in the time frame that they are expected to resolve them. I feel like at the AG's office, I worked at that volume, so it would just be ramping up again. The fact that I've been outside the AG's office actually puts a little distance. Had I come directly to the Court of Appeals from the AG's office, there might be cases I had worked on. I think there's a little bit of distance in that now, which is nice. I think it would be great. I don't expect any problems.
Thank you.
Commissioner Stanger,
No questions, thank you.
Commissioner Henderson,
No questions, thank you.
Commissioner Hoyt,
No questions, thank you.
Commissioner Bevel,
No questions.
Commissioner Hanson,
Hello, welcome. What is the most challenging litigation you've ever handled,
The Boys
and
State,
why?
the Boys State Training School litigation. It was difficult. There were about 12 lawyers on the other side, and there were the 3 of us from the Attorney General's office, and we all had our regular dockets to handle in addition. It was a difficult case in that the client's position was one that there wasn't really law that would suggest it was improper, but there were some other issues about it, and they didn't really have the appropriation to support doing things in a different way. The case was about restraint and seclusion, and if you stop using those restrictive practices, you have to have another way to deal with violent youth, and usually that involves more staff and more money, and at the time they didn't have that, and so it was really rough.
Thank you.
Commissioner Gray,
Thank you. Ms. Kramer, thank you very much for applying. We know from our experience that one of the hallmarks of the Iowa Court of Appeals is its collegiality in the way they can work together. They seem to enjoy working with each other. Have you been in such environments where you can assure us that if you were on the Iowa Court of Appeals, you too would be part of that collegiality?
I think I can get along pretty well. In the AG's office, I think I did well with my team. We had a great team. We certainly supported one another. Hopefully I gave you some references from my clients, and they can speak to how I work with others. At Mid-American, it's very collegial, and it's very cooperative, and the casework together, bouncing ideas off of one another, and then of course working with the client moving forward. I think it's important to be respectful of individuals, even if you have a different perspective on a particular case.
Oh, thank you. That's the answer I wanted.
Okay.
Commissioner Picklap,
No questions, thank you.
Commissioner Pearson,
Good morning, and thank you for your application. And thank you for explaining your broad experience that you've acquired through your career. And what would you say now? What are the maybe top 3 abilities that you would bring to the Court of Appeals?
Sure.
And I know 3 words is limiting.
Well, that's the hard thing whenever you ask for the top 3. Well, I think that my writing style and my ability to get to the point would be of value. I think I have enough experience that I know the value of sometimes waiting till the next day. If you have a difficult decision, I think contemplation is very important to coming to the right decision, and really being open-minded and considering the arguments of the parties. I think it's essential to show the parties that you have understood and really listened to the arguments that they're trying to make. If you can show that in your opinion, people are more likely to accept the answer, even if obviously in litigation one side wins and one side does not. But having a resolution that people can agree with and get behind, I think, is critical.
Thank you.
Commissioner Chase.
Thank you for your application. Can you talk to me a little bit about the difference between geographic diversity and diversity in the backgrounds of the people that might be on the Court of Appeals?
Well, I would hope that the commission looks for both and looks for a balance in the individuals who are selected to be judges. I say that as a Des Moines lawyer, knowing that geographic diversity works against me unless there is an acknowledgement that Judge May was a Polk City, a Des Moines lawyer. But I do think it's important. I think that people feel more comfortable having their cases resolved when they see folks that they know on the bench, when they are familiar with the judges. So I do think that's really important. I also think it's important to pick people who have different experiences so that you have the wealth of knowledge and the breadth on the court, and folks can bring all of those different things to bear.
Thank you.
Commissioner Hoyting?
No questions, thank you.
Thank you.
All right. Thank you very much for
Thank
your
you.
application, and we'll look forward to deliberating your application later today.
Thank you all.
Thank you.
Thank you.